Hi everyone, Neama Rahmani, real lawyer, former federal prosecutor, and I'm commenting on season 3 of The Lincoln Lawyer on Netflix.
Back to his holding cell during the recess, but I just got a call from the deputy. It seems the client's stuck down there. He's in a wheelchair, and there are currently no working elevators in the building that can accommodate him.
I'm sorry to hear that, but I guess we could take this arraignment down to the basement to accommodate him?
Yes, oh, of course, and thank you, Your Honor. Although, that would entail going down 10 flights of stairs, 11, if you count the basement, and back up again, and I wouldn't want to put your whole day's schedule into free fall.
We could always reschedule it for tomorrow, if the court allows it.
Well, normally, yes, but my client was actually arrested 2 days ago. And by law, unless a defendant waives time, he's entitled to be arraigned within 48 hours. So, aren't we in a pickle? Your Honor, in addition to all your incredible work for the community, I also happen to notice that you are the chairperson for the Superior Court's Committee on ADA Compliance. So you, of all people, know what a grave injustice it would be if a defendant were forced to waive his constitutional rights based on a disability beyond his control.
Ms. Acosta, perhaps it is possible that you and Ms. Crane can come to an agreement on this matter so as to salvage our chances of getting through our day together?
Absolutely, Your Honor.
When a criminal defendant is arrested, they have to be brought before a judge within a specific period of time. Now, it depends on the jurisdiction, but usually it's a couple days. So if the prosecution doesn't do so, that's a violation and the defendant has to be released. So that initial appearance or that arraignment is appropriate and something that's guaranteed under the Constitution, so people aren't held indefinitely before they can see a judge and argue for bail or anything else that's appropriate under the law.
Your Honor, may counsel approach the bench?
You may.
Now, Judge Turner, given what we just heard, we respectfully ask that you reconsider allowing Agent James DeMarco to testify. I think this puts the relevance of his testimony in a whole new light.
Your Honor, this is all innuendo. This dog won't hunt, and defense counsel knows it. He's just trying to kick up dirt.
It is not kicking up dirt, Your Honor. It is precisely the kind of third-party culpability theory that appellate courts have consistently allowed and consistently reversed when not allowed.
Congratulations, Mr. Holler. I will allow Agent DeMarco to testify. But in terms of this testimony, I'm keeping you on a very short leash. Relevant questions only.
Thank you, Your Honor.
So judges are the gatekeeper of evidence, and sometimes what they'll do is they'll say a witness is not allowed to testify because their testimony would be irrelevant or prejudicial. Oftentimes they'll ask for an offer of proof. Now sometimes things will happen during a trial that may open the door. So a witness that may have been previously excluded, the judge says, well, based on the testimony that's come in, one side or the other has opened the door to make that previously excluded witness their testimony relevant. So that's what's happening here.
There is only so much time the court can afford to wait.
Maybe we don't have to wait, Your Honor. I've been in the hospital all morning, so with the court's permission, I'll turn it over to my co-counsel, Ms. Crane, who can speak to this point.
May it please the court, it would be the height of prejudice to declare a mistrial at this time. Not only to Mr. Lacoste, but to the taxpayers of Los Angeles who have spent a small fortune on this case already. Mr. Lacoste has also spent a substantial amount of money mounting a defense, not to mention the enormous physical toll incarceration has taken on him. But perhaps most importantly, Your Honor, Mr. Forsyth and his team are now privy to the defense's carefully constructed strategy, and starting again would give him an unfair advantage in a new trial.
No more unfair than the advantage the defense would have, because they have also seen our strategy.
Luckily, we have a remedy for that situation. Rule 43 of the Federal Rules of Criminal Procedure clearly states that it is possible for a defendant to be tried in absentia. while it might often be used due to some egregious behavior or the defendant's choice, there is nothing that precludes us from applying that rule here.
Sure, and Section 977 of the California Penal Code, which is what actually governs trials in this state, says that the defendant must be personally present at trial unless they explicitly waive that right in writing, which obviously Mr. Lacoste is in no position to do.
Well, here are cases from jurisdictions including California where trials have continued without the defendant present.
Your Honor, regardless of what these cases say, continuing this trial while Mr. Lacoste is in the operating room is all but granting an automatic do-over to the defense in the event of a conviction.
Which is exactly what granting a mistrial at this juncture would do for the prosecution. Respectfully.
Well, it seems we are at an impasse. You both made very strong arguments, which I will take under advisement, and I will have a ruling for you after lunch.
In criminal cases, unlike a civil case, the defendant has to be present in the state of California. That's why they're talking about the Penal Code 977. Now, there are certainly some exceptions where the defendant can waive his or her right in a misdemeanor case at initial appearance, for instance, or at a pretrial. But during trial, the defendant always needs to be present. So what the defense lawyer cited, which are the federal rules, don't apply in California state court where we are. Now, usually the defense lawyer won't waive that presence because jurors are much more likely to convict when the defendant's not there. But in this case, for strategic reasons, the defense actually wants to go forward with a trial without their client there. Highly unusual, but it's part of the defense's strategy in this case. That's why the prosecution is resisting it.
Okay, now that
Mr. Holler, just a moment. Ladies and gentlemen of the jury, I apologize. I know it feels like we just started, but I have a quick matter I need to handle. So we are going to take a brief recess. Please go back to the jury room, stay close, and remember your admonition. Counsel, I would like you and the witness to remain. Mr. Bishop, do you have counsel present?
No, I don't.
Do you want me to pause your testimony so you can seek the advice of counsel?
No, Your Honor. I want to do this. I've committed no crime.
You are sure?
Yes. I'd like to continue to testify.
Bailiff? Mr. Bishop, will you please stand? Are you wearing a firearm?
Yeah, I am.
I want you to surrender your firearm to the bailiff. He will secure it until your testimony is complete. Mr. Bishop, hand over your weapon to the bailiff, please. Thank you.
I have a pocket knife too, Your Honor. Is that a problem?
No, it's not a problem. Please be seated.
There's two things going on here. Whenever a witness testifies and they may incriminate themselves, it's up to the judge to advise them of that possibility so they can consult with a lawyer. Just like in any other case, anything you say can be used against you, especially when you're under oath and you're testifying in open court with a court reporter present. So now that the judge has given that admonition and that warning and the witness is insistent on testifying anyway, the judge has done her job. Now, with respect to the firearm, different courts are different. We talked about previously state versus federal court. Federal court, even agents, they can't bring a firearm into the courtroom. They got to check it out. State court does sometimes allow for a law enforcement officer to bring their firearm in, but because there's this risk that the defendant may incriminate himself and may possibly even be arrested, that's why the judge asked him to turn over his firearm. Thanks everyone for watching me, Neama Rahmani. Comment on the Lincoln Lawyer. Please, as always, make sure to like, subscribe, and ring the bell for notifications.